Should your loved one have diabetes, heart condition, or other problems, inform the public guardian and the court of these problems. Request approval for medical treatment. You do not have powers to approve invasive medical treatments. What is a invasive medical treatment? Anytime you are going to take a scalpel and you're going to cut into the skin, according to the attorney that I've talked to on this, that's an invasive treatment. What if you need oral surgery, to have a tooth extracted? Well, technically you're supposed to go to the court, to the judge, and get medical treatment, but I think that you have to weigh that out. But by law, you're supposed to, any invasive treatment, you're supposed to get the court's approval on that. You do not have the right to tell a conservator who they can have for friends, for example, unless the friends are interfering with the conservator's treatment, such as their drug dealer or their pimp. How many times have I heard that somebody who is co-occurring with a substance abuse issue decompensate because some local drug dealer sells them $5 worth of methamphetamine. They end up in the hospital, and then the drug dealer actually follows them into the hospital. So in a case like that, if you know that's what's going on, you absolutely would have the right to block that person from seeing your conservator. So you are not, by law, and this is something that I get a lot of, you're not liable either civilly or criminally for anything the conservatee may or may not do. Although you're not negligent, you could be held liable. For instance, if you give the conservatee the keys to your car when the license was suspended, then you could be held liable for that. If the conservatee stole the keys, you would not be liable. So for those of you that were in our meeting yesterday, one of the things that a person that is going to lose in terms of their rights when they go on to conservatorship would be their license. The court will revoke their license to drive a car. So if you were to go ahead and let your son or daughter have the car keys, you would be held liable for that. But if and in that first year, the courts could allow them, if the person's stable, to resume their driving privileges, and they were to get in the car on their own and drive, then you would not be held liable. So the California Welfare and Institution Code 5300-5358-1 says neither a conservator, temporary conservator, or public guardian appointed pursuant to this chapter, nor a police officer acting pursuant to section 5358.5 shall be held civilly or criminally liable for any action by a conservatee. If your conservatee, let's say, were to be in a board and care and they were to cause damage to the walls or broke a sink or broke a mirror, you as the conservator are not going to be held liable by law, but I would recommend that you really think about that, because you don't want that to haunt your conservatee in the future if it's excessive. So if you want to talk to an attorney about that further, you may, but the law says you're not civilly liable.
Jim, I'd like to just say something on that. What Jim is talking about, if they do damage and it's something that you can cover, you might want to, because it can limit where they go for treatment.
Right.
If a person's violent, if they damage things, then, and word gets out, nobody wants them because it's a liability. So if they've done something and you can repair it, and it's within a normal realm that you can handle, do it, so that they will have other doors open and the facility won't say, well, put out the word, don't take him, because nobody will.
That's right.
That's kind of what Jim was talking about.
Yes, exactly.
It will follow around the conservatee in the case, any incidents like that, because the treatment teams tend to document a lot of thorough documentation, and so if there's an incident, it's recorded, and it might be there. They might be able to find this and recall it years down the road. It could be a problem.
Okay, thank you, Alexander. Moving on, we're talking about apply for services available for mental health support. So if the conservatee does not receive Social Security Supplemental Income, SSI, or Social Security Disability Income, called SSDI, or Social Security, then you should apply for these services at the Social Security office. Give your history, and that's what we talked about yesterday, how to write an effective mental health history. And this is one of the places where you would utilize that mental health history. You give your history, symptoms, and gravely disabled paper that you put together for your loved one to Social Security, as this will help them to put together a strong case for these resources. If your loved one refuses to sign these resources, then your LPS conservatorship will give you the power to acquire these resources. The funds are to be used for the benefit of the person with a mental health diagnosis. When the appropriate resources are approved, it will open doors for treatment. And I will go on to say that basically you are what's called a payee at that point in time, and are to open up a payee account, quote unquote, at one of the banks, and then of course share that bank account with Social Security so they can make direct deposits. Also apply for Medi-Cal and Medicare. Generally, when SSI or SSDI is approved, Medi-Cal is also approved. You can request emergency Medi-Cal to be approved immediately. If a person receives SSDI, then Medicare will be granted 2 years later. Be sure to contact Social Security to have Medicare approved. That's one of the most important things I will share with you about the insurance part of it. If you're on SSI and Medicare, we call that Medi-Medi. You're going to register with the if it's Orange County, it'd be Cal Optima. There's a equivalency there in Los Angeles that Gail can tell you about later. But basically, you're going to get the Medi-Cal in your own county where your payee resides. And I lost my track here. So you want to, well, let me move on. So I'm getting sidetracked. So these services are available even when the person is not under the LPS conservatorship, but the person must sign for those resources. Often a person is too ill and will refuse to sign. Therefore, as I said, the conservator can apply for the services. Many people with a mental health diagnosis are not capable of appropriately handling these benefits. Therefore, you can request to be assigned as a representative payee, and that's what we've just talked about. So you're going to handle all the funds for your conservatee. You ask the patient's treating doctor to fill out the representative payee form. Then give this form to the Social Security office, often a representative payee bank account in both your name and the name of the conservatee. The conservatee does not have access to this account. Only you will have access to these funds. The funds are reported as the patient's income, not your income. The funds are to be spent on housing, food, and personal needs, such as clothing. A person does not need to be conserved for you to be the representative payee. And I actually was representative payee for our son before he was on to a conservatorship. When SSI, Social Security, and SSDI is approved, then Medi-Cal is approved. So if you have both SSI and Medicare, you have Medi-Cal, Medicare, both, that's really important if your loved one tends to have a history of ongoing psychosis, needing hospitalization, repeated hospitalizations. That will absolutely get you in, because oftentimes otherwise, if they're on the equivalency of a basic Medi-Cal only kind of insurance, it doesn't pay the hospital bills per se, and they won't want to hold him. So it just depends on what their needs are. So double check with your Social Security office to make sure they have applied for Medi-Cal insurance. You should also apply for Medi-Cal separately. Medi-Cal will pay back medical expenses for 3 months. If a person receives SSDI, then after 2 years, contact Social Security and request Medicare. Here in Orange County, there was a a mother whose daughter needed to be hospitalized and she did not have Medi-Cal or Social Security at that point. And they cover the expenses until the SSI funds, and they come out as a large amount. And then those SSI funds are to pay back what's owed to the hospital. So a person can have private insurance as well as Medi-Cal and Medicare at all the same time. You do not have to terminate your private insurance. All of these services open the doors for treatment. One of the things that I would like to talk about, that very paragraph in that sentence, is that I really don't know what they're doing in Los Angeles so much, but for those of you that are in Orange County, if they have private insurance, the private insurance payer has are recognized here in Orange County as having the right to pull your conservatee, or if they're just trying to get conservatorship, to pull them out of that hospital and transfer them. So we've had cases here in Orange County where the person is pulled out after I've educated the family how to get a conservatorship. The private insurance company pulls them out, telling the hospital that they have an account set up with another hospital out in Los Angeles, and they put them in there. And doggone it, a lot of those hospitals that private insurance companies contract with are not wanting to go through the process of putting somebody onto a conservatorship. So just want to keep that in the back of your minds. I, again, don't know if Los Angeles, Gail, are you experiencing any of that in Los Angeles?
Okay, what you're referring to is, and this is something so that, as you know, the people need to know. If they put somebody in a hospital and you're trying to get the conservatorship, and I'm assuming you're talking about before they got the conservatorship, not after.
Okay, it happens after too, Gail. Go ahead.
If they put somebody, we're going to talk about before, if they put somebody in a hospital in another county before they get the conservatorship, and you need that conservatorship, the doctor in the other county can apply for the conservatorship in the county that's the resident of the individual. So if they say, well, we can't do it because he's not in the county, let the doctor know that they can apply. Like if somebody's in San Bernardino, the doctor in that hospital can apply for conservatorship in Los Angeles or wherever the resident of that individual. Now, if they're pulling them out and you are the conservator, straight to the director of behavioral health in Orange County, because before they transfer them, they're supposed to have your permission. Okay, if that helps. And I'm going to go back for a second to SSI. When you apply for SSI, now this is actually applying, and sometimes it can take 3 months, 6 months, 12 months before you get the money. When you get the money, they throw it at you, a big lump sum, and they give you only a few months to get it spent down. If the person is living with you, then charge them rent and keep a record. They owe you so much for rent and food for each month, so that when they give that back pay, you can take money out. Because if you have SSI and it goes over $2,000 each month, they will audit you. And it's not a big deal when they audit, but it's more stressful. You don't need any more stress. So at that point, you don't ever let the bank account go over $2,001. Pull out a dollar if you have to buy them a candy bar or whatever. Right. But you can put that money aside, and most of us parents just kind of put it in cash and save it for when they're better. Okay, so go ahead, Jim.
So the last of it is that private insurance can pay for an Institute for Mental Disease, IMD. If you have problems with this, then contact Catherine Trapinski at 310-201-0022. And she's also listed in the back of this printouts that you have in the resource section. Catherine's an attorney who files class action lawsuits against private insurance companies who are not in line with parity laws. And that's one of the things we wanted to bring to your attention as well. So at this point, Alexander, can you lead us on through with LPS conservatorship of the estate?
Yes, I'm Alexander, LPS Conservatorship of the estate. So the conservatorship comes in the two parts. Everybody has conservatorship of the person, but what I'm going to cover is in this section is conservatorship of the estate, as we've already started discussing it. And so when the conservatorship, the application for the conservatorship is filed, at that time, the public guardian is going to begin their investigation into the finances and the economical state of affairs, and so the public guardian is going to do that investigation. You want to volunteer for them as much as you can, because you're going to want to try and get conservatorship of the estate, unless the affairs and they're doing a pretty good job financially and spending their money as they should be, and saving money too. Then they may not need it. But in a lot of cases, you're going to want to cooperate with the public guardian to make the case here with their investigation. So if the case is they have bills that need to be paid, student loans, outstanding court cases, that could be fees, penalties from court cases, and other sentences, you will, if you do have the outstanding bills and the debts, you're going to probably try to apply with a creditor and a credit. It's called a credit consolidation agency, and the credit consolidation is going to relieve you of paying the debts in 100%, and they negotiate a lot of the debts, and you can always negotiate with them, and you want to try and negotiate to maybe 10-15 cents on the dollar, as low as possible, so you're not burdened with paying all these. A lot of times they spend money frivolously, and you don't want to have to, if they spend frivolously, if they're buying a lot of things that aren't very necessary, and then you don't want to be responsible for all the debts. Let's see, back at the beginning, the treating doctor is not involved with the conservatorship of the estate. It is a public guardian that makes a determination, and they, after they complete their investigation, they will either determine yes, in favor, or against the conservatorship of the estate. And you can also ask the court directly for a conservatorship of the estate at any time any time during the 12-month conservatorship, or if you have it longer than 12 months, you can do it then. You may want to try and check their credit yourselves, and then you can identify a lot of the assets, because this is a point when you want to try and identify the assets and the debts, kind of like a sheet, an accounting sheet. You are not personally responsible for these bills, but you have the power granted by the court to negotiate with the debt, from the creditors. And we've heard of power of attorney. What the conservatorship of the estate here is going to be equivalent to power of attorney, but it's equivalent and greater. So I think the way it works is that you are given the de facto power of attorney for the conservatee, and you can contact their banks, their Visa, and if you're applying for benefits, all this is kind of under the umbrella of power of attorney, but it goes further, and you can make a lot of decisions for them. Let's say a judgment was filed against the conservatee. It can often be removed from their credit report. You may be able to file as a disability or disabled status and have it removed from the credit after 3 years. You should have an attorney provided to you by the court, and make sure that you cooperate with the attorney, and they should cooperate with you, and they should oversee this and answer any questions that you may have. Okay, Mom.
Okay. Renewal of the conservatorship. The court will send you papers for the renewal of the conservatorship. Start renewing the conservatorship 3 months. That's if you're in Los Angeles. Public Guardian has asked us to have it get people involved 3 months before the conservatorship expires, because they need the time to do the investigation. Basically, what you need is they send you a packet. You need the doctor's declaration, and the declaration states that the person is still gravely disabled. You need 2 doctors to sign that. Usually your doctor will sign it, then they have somebody else to kind of oversee, do a quick investigation, and the second doctor will sign for it. If the doctor refuses to sign for the person being gravely disabled, then I would go, if you feel that they still need to be under the conservatorship, I would go and get another person to sign it. Now, sometimes the conservatee will not contest the conservatorship. There are people, they have pretty high-powered jobs, so they want to remain under the conservatorship because there's not a medical directive in the state of California that will help them if they should start to decompensate. So a lot of times people will ask to remain under the conservatorship, because if they do start to decompensate, go off their medication for any reason, we can get them back in the hospital pretty quickly, maybe a weekend holiday, get them back on meds, and they're good to go. Where otherwise you have to wait for them to decompensate, to harm to self, harm to others, which could take maybe a year or longer till they get to that point. So you can put them in the hospital. If the conservatee contests the conservatorship, it's incumbent on the conservatee to prove that they are no longer gravely disabled. And the treating doctor must appear in court for that. So you want the treating doctor to appear in court. Now, sometimes the treating doctors will go to court. They really are ticked off that they have to go. And we're trying to get it so that they can do it via the video. Right now with COVID, everything, nobody goes to court. Everything's done via WebEx. So we're trying to keep it so that the doctors can continue to testify like that.
So Gail,
yes.
One of the things we want to do, and you asked me to do, is to share differences. Here in Orange County, the doctors do not have to testify in court. There's actually a forensic psychologist that the court assigns to evaluate the conservatee. And that forensic doctor is the one who presents in court, not the doctor. Also, it's 3 months before the conservatorship expires. It's the same. They recommend that you file at least 3 months in advance to renew it. I'm sorry.
I like to do that in Orange County. I would prefer that we had somebody that would go around and do the same thing, but we don't. They use the doctors, and they want the doctors to go and testify. Be sure that doctor has seen your individual, the conservatee, recently, like within maybe the last 24 hours if possible. Because if they ask them in court, when was the last time you evaluated them? And they go, well, last month. The judge might be inclined to dismiss the case. If you are remaining their conservator, or maybe the public guardian was a conservator and you wish to be the conservator, they have to agree to allow you to be the conservator. They do give them that right. And sometimes the patient doesn't want the family, but most often You might start out with the public guardian as a conservator. When they get to the IMDs, everybody's talking about, you're so lucky your mom, your dad, or whatever, because the mom and dads can take them out for lunch, bring them things, all sorts of things, where the public guardian doesn't do that. So many times they will ask to have you to be the conservator. And we discussed yesterday the pros and cons, and we'll talk a little bit about that too. But if you get to court and the treating doctor is not testifying appropriately, or there's a problem all of a sudden, or they don't show up, ask the judge to have another doctor evaluate your individual. They have normally, not with COVID, but normally we have buckets of doctors at the court, and they will just ask one of the other doctors to go and do a quick evaluation, and they will, and come back, and most likely they will say that they're gravely disabled. The conservatee must appear in court as well as the doctor if the person is contesting. If the conservatee does not contest, the doctor does not have to appear in court. Neither does the conservatee. They just have to let their public guardian know that they don't want to be in court. Now, if a conservatee is in jail or in the hospital and they don't want to go to court, and that does happen, the court can assign and have an evaluation of them where they are and consider that they had appeared in court. Because of COVID-19, it's a whole new ball game. Everything's by WebEx. They don't want anybody in the courts because they don't want the judges getting sick or the attorneys. So everything's done via WebEx at that point. Let's see. We talked about the doctor's declaration, a second opinion. You can always get that. You can always, if there's a problem in court, don't do it at the last day when that conservatorship's supposed to expire. Be sure the hearing is a little bit earlier. It's incumbent on the conservatee to prove that they are no longer gravely disabled. If the conservatee gets up there and says, Your Honor, I'm going to get a tent, go live on the streets. I'm going to eat all my meals at the food banks, and I can get my clothes from Salvation Army. And you know they can do that, but they don't. Then let the judge know, yes, they can do that, but they're not safe doing that. When they're living on the street, they're terrorizing other people, or they're being terrorized, being victimized. They can get the clothes, but they wear the clothes for a month, 6 weeks. They don't change their clothes like they should. Or the food, sure, they can go get the food, but they've lost significant weight. That is a lot different from the person saying, I can do this, this, and this. But if they can't do it in a safe manner, that is definitely gravely disabled. So don't be afraid to speak up, ask for a continuation if you need it, if you need to get another doctor to go in there, or to have another evaluation, or to speak up and let them know why you believe this person is still gravely disabled. And remember, gravely disabled refers to food, clothing, or shelter. You only need one, but we try to hit all three. Okay, Jim, you want to take communication with doctors?
It's the conservator's responsibility to know the medication. One of the things we talked about yesterday, and Gail's always been a strong advocate for, is keep a journal of your loved ones, before the conservatorship and during the conservatorship. You want to keep notes not only on behaviors if they're not doing well, but you want to keep notes on the medications. If a doctor were to change one of the medications, we want to really watch your conservatee to make sure that that is having the effect. If it's a new medication, it might take months before it's really working. We're also going to be watching for maybe acute side effects, and if so, we want to communicate that with the doctor. The treatment and all information pertaining to the welfare and the patient, needs to be considered. Doctors must, by law, the California Welfare and Institution Code 5328.1 says, communicate with you, the doctor, directly pertaining to the treatment of the conservatee. Most information can be relayed through the charge nurse, the social worker, or the caseworker. but there are times when it's necessary to communicate directly with the doctor. Information provided for LPS conserved patients. The California Welfare and Institution Code 5328.1, public or private treatment facility shall give the prognosis, medications prescribed, the side effects of medications prescribed, if any, and the progress of the patient. Written authorization is not required. Verbal authorization is acceptable. And I've had times when the doctor would want to change a medication. Maybe the hospital saw something that needed to be changed. The hospital staff would call me and say, well, the doctor wants your permission to start this new medication, or to add something or take it away. You can give them a verbal, and they'll want you to, when you're available to them, to sign that, but it can be a verbal approval over the phone. So, Gail, you really do well on that because the doctor's time is limited. Do you want to read on from there?
Sure. When you're talking with the doctor, keep it short and pithy, because the doctor's time is very limited and they will talk with you. But if you get on the conversation and you go into all this stuff with the doctor, they're not going to give you that time. In fact, you might be talking and they might go get a bite to eat for lunch and come back and you're still talking. So write down what you want to say, make your points, be very to the point. Know the medication your loved one is on. On that journal, when the doctor changes the medication, know about it. Now, when you put your loved one in a treatment facility, you want to be very precise on that contract, write specifically on it, that any change in medication, treatment, or placement must have your express permission. You are the conservator. Write it on their contract. They don't like it, but too bad, because you don't want them changing medications. All of a sudden, you're wondering what the heck is going on with your loved one. I mean, they're all over the place. And I hate to say it, but some doctors will give 5, 6 psychotropics. Which one is working? Your goal is to put the person on one medication for schizophrenia. If you have to, one for bipolar or mood swings. But actually, a lot of the newer medications will cover both of those situations. You want as few medications as possible. So know about medications, read about everyone that your loved one is taking on the internet. Keep in mind that some of these medications are good for a person with mental health, but not with mental illness. So, be very aware of what they're taking, how much, and when. And when they change it, they need to have your permission on that. Going back to, if the doctor does not talk with you by law as a conservator, they're supposed to. If your child was 5 years old and you took him to the doctor and the doctor takes him off without you, does whatever they want to do and treat your kid, you're not going to allow that. It's the same thing. You're overseeing the recovery of your loved one. And this is very important. Medications, I'm going to go let Alexander do that. And I did kind of say a little bit. Alexander?
Okay, well, a lot of you are going to already be conservators, and some of you are still trying to pursue a conservatorship over a loved one. But you're going to be involved, and when you do get your conservatorship, you're going to be more involved, I think, in their treatment. And so where a good place to start here is with medication. We want to know what they're taking, and it, like Gail says, there could be more than one medication. Usually they're on a kind of a cocktail, and they take the medication at different times during the day, and so you want to know the amount of the medication, the dosage, if they're already taking as much as possible, and if it's effective, or if they're just taking a little bit and there's room to work with the treatment where you can increase the dosage. So that's what you want to know, and that's the first question probably you ask. And then do a little research on the medications have side effects and what it's supposed to be treating. So your depression medication is not going to treat maybe your mood swings. You may use Depakote in depression. An antidepressant. You're probably pretty familiar with a lot of the common antidepressants. So know why the medication is prescribed. There's a dosage of the medication. Be aware of side effects, keeping in mind that even aspirin lists some very severe side effects, but these are so rare that it shouldn't be something to deter you or really scare you away from using the medication, because the medication it's been approved because it is considered safe, and it's also considered to be useful in the treatment. And so while they will list that the medications have some severe side effects, these are very unlikely, and don't let it be too distracting. Some medications begin working in 3 to 4 days. Some may take longer and they accumulate in the system. You can have a blood concentration, and it may take a few weeks for the medication to accumulate, or 2 weeks or even 6 weeks. And then at that time, you might start seeing some results. If you still have questions about the medication after you've done the research, then do not hesitate to contact the pharmaceutical company, and they could inform you further. They are very helpful, informative, and if you're having a difficult time with financially, they have a lot of samples, and you may be able to get a 30-day sample supply, or they may be able to come up with some kind of a financial incentive or something, some way to help you. Yeah, so your goal is to find the best medication that gives the least side effects with the greatest clarity of thinking, because we want the conservatee to eventually be independent. And so if the medication, usually, I think the most common side effect you come across is drowsiness, and then it's appetite. The medications tend to put on a lot of weight on the patient. So you don't want them to be too drowsy, because you want them to be supporting themselves in the end, and so they can't do that with their eyes shut. The most common way to determine the best medication right now is trial and error, just like the scientific method we learned in high school in our science class. You want to make a prediction, and then you test your prediction. So you make a prediction and describe what you're going to change and what you want to observe, and then that's the scientific method. And then you test. They call it a hypothesis, one variable at a time. If you notice the change is positive, then you've done something that's working, and if your change is negative and not beneficial, then you don't want to keep doing that, and you don't want to keep reproducing. Reproduce the negative results. So that's when you may want to speak with a doctor and say, well, this medication is supposed to be treating his symptom of maybe a negative or a positive symptom, and he or she maybe doesn't want to clean up their dishes after they eat, and maybe you're trying to use a medication to help motivate them to not be so resistant to doing the dishes, and then if you notice the medication is just giving them side effects and they're still not cleaning the dishes, then you can try a different medication. And if you find something that works, then you want to try and hold on to that. Recently, now a more futuristic approach is DNA testing, and they'll run their genome and do an individual DNA test, and this can determine which medications would be more effective and gives you a whole list of possible symptoms and genetic markers that are different and variant, mutated. A DNA test may be a direction to explore, but is not always guaranteed to be accurate. It's still kind of a newer procedure. Okay. And when you do change medications, one method that's wise is the titration. So we don't want to change things too quickly, and we do want to notice the differences and the reactions. So if you add a new medication, you can add a little bit, and instead of going to the highest dose right at first, you want to start lower. But usually the medication is what the doctor's department. So you're going to want to educate yourself and research, and then you can still speak to the doctor about the medication and ask them whatever questions if maybe come up for you. One suggestion, but we don't want to be real forceful with the doctor, and you want to let the doctor kind of make their own decisions, and don't try to make the decision for the doctor or put a lot of pressure on them. For example, doctor, I've been reading about a certain medication. Seems like it might be helpful for my son or daughter. What do you think if we try this? Or just ask for the MD's opinion. NAMI has a family class which will discuss a lot of the medications. Okay, I think are we going on here?
Yeah, very good. Thank you.
Jump in. I'd like to just add, Alexander, you made some really good points in that, and I really like the part where you were recommending that maybe they were to reach out to the manufacturer of the medication, that's Squibb or whoever that is as well. One of the things that I wanted to say too was that I use a app that I get online. It's called drugs.com, and you can identify medications by pill number, by pill size, by name, what have you. And they do a really good job of listing the side effects of various medications. Using that, I caught one of the medications the doctor had put my son on, and I went, wait, we need to back up on this. I should have caught this sooner. Our son was suffering from several things, but one of them was anxiety and high blood pressure. I said, did you realize that the medication that you're putting our son on is some of the known side effects are anxiety and high blood pressure and some other causes, especially for those that have long-term substance abuse issues, and our son has long-term substance abuse issues. Who prescribed this? Really, did our doctor prescribe this? So, I asked him to he was in the hospital at the time, and I asked the staff there to reach out to the doctor and, let's get that changed. Let's call me and we'll talk about something else. But that app is really, really useful. The other thing too is I remember when it comes to medications, years ago when our son was in one of the hospitals, there was a family that was discussing with me that it just seemed like her son was resistant to every medication provided for the schizophrenia. He just seemed to be resistant to it. Went through the DNA testing to see if there's a better medication than others, and just nothing was working. Recently, I read an article called Bottle of Lies, and it talks about the fact that none of the medications are made in America. They're all made in India, especially the generics. They're all made in India and China. And so, the book called Bottle of Lies talks about the fact that they fabricate all of the strict guidelines that they're supposed to be following. So we want to, look at that. I can't get anyone to really discuss this, but it's something we should be aware of. And one of the other things that I found out recently as well is that some of these medications will actually eliminate specific vitamins from the body. And so consequently, I would call the manufacturer and ask if they have any data on that as well to see if it's any of the medications that your conservator is taking might lead to a depletion of vitamins. And then we could supplement those vitamins to help make sure that they're getting enough vitamins. I just wanted to throw that in there. Thank you.
That was good, Jim. I like that part. I think, we talk about holistic medications. Now, if you're going to put your loved one on holistic and take them off the psychotropics, be cautious because, one, they very well might decompensate and you won't ever get to be a conservator again.
Right.
You can do the holistics, but keep them on the psychotropics because you will be requested to be removed as a conservator if they find out you're doing that. But your your B12s, your omegas, those are all great for helping to rebuild the brain. And believe me, the brain can be rebuilt and restored to a great extent. So don't hesitate to do that.
Yeah. So I hope you didn't misunderstand. I wasn't suggesting you take them off of medication and put them on vitamins. No. I'm just saying let's do the blood draws. Talk to the doctor about doing the blood draws, and let's look for vitamin deficiencies and keep an eye on that. That's really where you can monitor it.
Jim, I know you would never take anybody off their medications.
No.
No, that's really good. Okay. Thank you both very much. Keep a journal of your loved one's behavior when you're doing the medications, what medication they're on, the time of day, how the dosage, what behaviors you're seeing, good and bad. That does make a difference. And if you keep a nice, clean chart that's easy to read, you give it to the doctor. Let me tell you, they appreciate that a lot. It really does make a difference. So as a conservator, and some people will call me, they're conservators, well, what medications are they on? They don't know. That's your responsibility. I mean, would you let a doctor give your 5-year-old medication without not knowing what it is? You really have to know what medications they're on. Your goal is to help your conservatee get clarity of thinking with the least amount of side effects. And do not settle. When the doctor says, oh, they're doing fine, you mean you tranquilized them, they're a walking zombie and they're not bothering anybody? No, don't allow that to happen. Keep focused of where your goal is. If you have to go back and look at the pictures, what they were like before, that's what you want. So work really hard to get that point. Your journal will make a big difference in all of this. Alexander, did you want to say something about being unreasonable? Or I think Jim pretty much covered that.
Yeah,
they can be removed as conservators. So it's a good idea to try and get along and agree with the doctors. They will take suggestions, and they do make mistakes. The doctors aren't infallible. Doctors can make mistakes. I guess they're considered field psychiatrists. So that's a little different, and they have they're trying to always be on their feet and be kind of quick and candid and quick. So they make a lot of decisions, and they have a lot of different patients. And I don't know if they're kind of working alone. So if they make a mistake, it could happen. And so if you kind of check their work, that's a very, very good thing to do for your loved one.
Let me throw in too that the pharmacists are so good. I mean, they really know these medications. And I had my pharmacist call me just a couple of days ago and said, you've got your son on propanolol, I believe it was, if I remember correctly here, propanolol, and he has high blood pressure, and propanolol can exacerbate the high blood pressure, and you might want to call your doctor and ask them about that. So I would say that absolutely talk to your pharmacist as well. They really know these medications and will do or can create or cause. They're a wonderful resource.
Okay, I'd like to add one more thing. If your patient, you need a new medication, and the doctor says, well, your insurance doesn't cover it, Medi-Cal, Medicare, or private insurance, the doctor can write what they call a formulary, which is no more than one page, and it's a form. And they just say, we've tried this, this, and this. We would like to try this other medication. So they can try it, and then most likely these companies will approve it. It's not a big deal. You just have to kind of push the doctor a little bit. A lot of times you can get if you want to try a different medication and it's not approved on your formulary company, and get free samples. So you can try a few without going through the whole big deal of a formulary, which is kind of a nice thing to do. It makes life a little bit easier. Okay, driving a car, Alexander?
Yeah. Okay, right to drive a car. Well, at the beginning of the conservatorship, the right to drive a car is taken away unless you have a special case and your attorney's argued otherwise. Your attorney has to argue otherwise. It's kind of an automatic. It's sort of by default. So they're going to take away the driving license, and but we can reverse this, and whenever you feel like the time is right and they've reached a point in their recovery that that they are safe to drive a car now, then the first step would be to speak with your doctor, and at your next session with the psychiatrist, we have a form. This is really the easiest way. You might have seen this, I guess, if you had the class yesterday. This is a book, a little bulletin. It's Helping Your Loved One. It's from the County of Los Angeles. And at the end of it, what page is it? You have this form for here's the form for the DMV. I guess it's filled out by the doctor and the conservator. And these, all you do is you give this form to the doctor, and the doctor will complete the form, and then it's submitted to the court. So when it's submitted to the court, you might contact the public defender, who's the attorney representing the conservatee, and their attorney will file for a hearing in the court. This hearing can be held if for some reason you have a hearing and it doesn't work. Usually things are by the book, but you never know what could happen. And you can have the hearing once or twice a year, but not more often than 6 months. And the public defender will submit this form to the judge, and then the judge will clear the driver's license and clear the flag on the license. And then at that point, you're still not allowed to drive, but you return to the DMV, and the DMV will. I haven't seen this for so long, but the DMV will give your driver's license back. So the process, it's, I guess, in 3 parts there. It's from the doctor. You have a session with the doctor, and then goes straight to court, or the public defender, and then court, and then to the DMV. And then they'll be able to drive again. I hope I didn't. When the conservatorship terminates, you should also, instead of just starting to drive again, if you don't renew the conservatorship, or if it's terminated because of a jury trial in any different way, you should notify the DMV, and and you should be able to reinstate your driver's license through the DMV. And there may be a safety interview. The DMV uses a department that's a safety office, and it's a special department to ensure the public safety via the transportation. And all they do is they have a short hearing. It's not the hearing that you had at the mental health court, but it's this is from the DMV, and they just ask you a couple of general questions to make sure that there's nothing out of the ordinary, and then they submit all the paperwork, and your license will be reinstated.
Let me just add, the book that you were referring to, Alexander, it has the website for it, that file.lacounty.gov/DMH. It's on the paper that you have. And it also has the doctor's declaration. It has wealth of information in that booklet. The Helping Your Loved One, a Family Guide to Conservatorship and Involuntary Treatment. So thank you very much. Jim, do you want to start with what do you do when the patient decompensates?
Sure. There's lots of reasons why people will decompensate, but the primary thing that I hear from a lot of families that call me is that their loved one was doing really well. They were perhaps hospitalized. They came out and they're doing so remarkably well. They're taking their medications. Were able to work in a way that was appropriate and that type of thing. And at some point they thought, I really don't need these medications. And so they will go off of their medications. In here it reads that it's only in the psychiatric hospital where the medications can be forced. So you, as the conservator, cannot force somebody. You can encourage them, of course, but you can't force them to take medications. A board and care IMD, which is the Institution for Mental Disease, also known as a lockdown treatment facility, or other treatment facilities, cannot force medications. They can only encourage the use of medications. The person may have to be returned to the hospital to start them back on their medication should they continue to refuse taking their medications. When the conservatee is in the treatment facility and the medical emergency arises, the facility should transport the patient to the hospital immediately. If the facility downplays the emergency, you have the right to pick the patient up and transport them to a medical emergency room for treatment. All non-emergency medical invasive procedures must be approved by the Superior Court 95. You're not allowed to approve experimental treatment. This includes dental work. If the conservatee stops taking the medication, you cannot succeed in encouraging your loved one to take the medications, then you should have the conservatee transported by the police to the hospital for treatment. This is one of the things that I really just want to hug Gail so much for. This is something that she taught in her classes. I came back home and I was trying to tell I won't name people, but people in our behavioral health department that, absolutely, if somebody's on a conservatorship, we don't need to have them 5150 in order to get them back into the hospital and get them restarted on their medications. So I was sharing Gail's information, and they went to one of our county council attorneys, and they said, "Oh, yeah, that information's right." And so went, kudos to Gail, she got it right. And so I so appreciate that. But again, you can have the conservatee transported by the police to the hospital for treatment. And I called the police department and said, I'm the conservator of my son, and I'm asking that the police come out here and help me to get him, into an ambulance, because out here they were using ambulances and not transporting via police cars. I know they've changed that in LA, but they said, "I'm sorry, sir, it doesn't work that way." Well, they were right. They didn't know the law until finally behavioral health, reached out to the rest of the community after learning that Gail was right. So I give her kudos on that. The California Welfare and Institution Code 5358.5 gives the conservator the right to request police transport to place the patient in the hospital when he or she deems it necessary. The court has found the patient to be gravely disabled. Therefore, no evaluation is necessary prior to treatment. Your responsibility is to provide for the continuity of recovery. Often the police will request an ambulance for transport. So this is one of the things that one of the mental health attorneys here that was very involved in our county council and mental health courts was saying it. If the conservator doesn't have this right to have if the conservator doesn't have the right to put their conservatee into the hospital, by their own authority, then really what rights do they have? What is their position even? And that it, basically we're saying that this is something that he had discussed with county council and other attorneys for some time. But again, no evaluation is needed in that case. Because most police departments are not aware of the 5358.5 law, the Department of Mental Health has established a point person to assist with transport of the conservative. And then, Gail, why don't you take it on from here, if you will? Because these are LA resources and things are maybe a little different there. So why don't you go on?
In Los Angeles, basically, anytime you needed to have your conservatee transported back to the hospital to get them jump-started back on medications, you'd have to go to the police department, you would have to educate them, take the law, a copy of your conservatorship, and a written statement stating that you're requesting that they transport them to the hospital. Talk to Dr. Curly Bonds, who's medical director or something. He's right up there in DMH. And I said, can you give us a point person? So the families, they've been so stressed for everything. Everything you do, you have to fight for. This is ridiculous. They should not have to fight for this. So if you can give us a point person, somebody that they could call and say, this is what I need, and have that person have a team that can come out and transport the person to the hospital. And he looked at me and he said, no, I'm not going to give you a point person. I'm not going to have somebody from South Bay go all the way to Antelope Valley. That's ridiculous to transport somebody to the hospital. I'm going to have in all these different areas contact people, but you'll have one person that you contact. They know who to contact, and your loved one will be placed in the hospital. And true to form, they have honored that word and they do it. The court said that they're gravely disabled. You do not need somebody coming off the street, a social worker or whatever, or even a psychiatrist and saying, oh, well, they're not gravely disabled. Go to court and tell that to the court. So now it's the least stress thing. Your loved one goes off medication for a week or so, and you go, they really need to be on their medication. You call Miriam Brown at DMH, and send her a fax over a copy of your conservatorship papers. She takes care of the problem. The person's in the hospital usually that same day. And because we treat so quickly and so early, many times they just go in, they get a shot or they get a couple pills, or they stay maybe a weekend for a little vacation, a little R&R, and they're back out good to go. Makes life so much easier. You're not waiting for them to decompensate. So we are blessed in LA County that DMH has stepped up to the plate and gotten that aspect of treatment through. So you really don't suffer any stress except just when are they going to be here kind of thing. So I'm really thrilled about that. And I do want to say, if you're looking at the paper and it has Superior Court 95, that's Department 103 it's supposed to be. So I apologize for that. Okay. By the way, do not wait for your loved one to decompensate. They go off the medicine and you're the conservator, get it done right away. Keep the continuity of their recovery going forward. The law that this is on the next page. And then you also have a chart showing the different areas where the contact people, but make life easy. Just call Miriam Brown. Let her deal with it. Don't call her on a Saturday or Sunday. These people do like their holidays, their weekends. Okay. What to do if the conservatee goes AWOL, Jim?
One thing about that is if they are decompensating or if their symptoms are kind of returning, that the quicker you can take action may result in a quicker remedy and a quicker resolution, because if you just let things go and digress, it may take longer to recover and get back on track.
That is so true. Thank you. Jim?
Yes.
AWOL?
So, yeah. This is a really big problem. People who disappear, and we're trying to find them, are oftentimes, not a nice term, but sometimes they're referred to as frequent flyers. These are people who just tend to up and disappear and take off and hitchhike across the country, or in some cases where families are maybe more affluent. There's been cases where the son was an avid surfer and liked to ride the big waves, and when he would hear of a big storm someplace around the world, why, he bought himself an airplane ticket and took his surfboard and checked it into baggage and went surfing in Australia. And the family said, "Where'd he go to?" Filed a missing persons report, couldn't find him, and finally, in Australia, if you're walking down the street and you're showing signs of psychosis, laws are so different there. They just grab you, they take you into the hospital, and they just slam a needle in your arm right there. I mean, there's none of the stuff that we have here. But, unfortunately, a lot of the missing persons are not found. I would like to just share with you off the top of my head a website called outpostforhope.org. And Outpost for Hope really started with a gal whose sister took off and went missing, and she searched, for like 9 years before she found her. And I just will share with you that when she was found, she had broken eye sockets. She'd been abused and beaten up, was pregnant. To get her back and got her stabilized, and was taking care of the daughter and all of that. And so in that website, you're going to find directions on how to fill out a missing persons report. Tons of information in there. I've worked with the former chief of police down here in Tustin, Charlie Solana, who was in charge of a CIT. And oftentimes we would find a police department that was not willing to take a missing persons report because the parent was either out of town or out of city, out of state. And then, so the chief would call them up and say, "Wait a minute, bub," talk to their commander, say, "You guys need to do this. This is the law," and get them to work with the parents on this. But, I think of many times where parents are out there actually with their flyers. That website is going to talk about the, I believe it's been so long, I can't remember the name of it. I think it's CIC or something like that database. It's where they put in all the details on the missing persons. Only the police can enter it in. There's other websites that families can enter in photos and missing persons as well. But all too often, when somebody's found, the police will call the parent. I've had them call the mother in Arizona and say, "Well, we found your son. He's here in Los Angeles at a fast food restaurant. And oh, by the way, now that we know where he's at, and I've told you the address, he's no longer missing. So we're taking him off the missing persons report and wish you the best of luck," and hang up. I mean, and I've talked about this with our local police departments. It's the same thing. This is one of the areas that I really want to make a change. In that website that I've given you, there's actually a forensic portion showing how they reconstruct a person's skull, trying to identify the individual, putting her photo. They reconstructed with clay and put a wig on and so forth. And try to help families, because there's literally tens of thousands of Jane and John Does buried in cemeteries across the United States. The families never have closure on this. So it's really important that when somebody goes missing, you call immediately. There's no waiting. When somebody has a disability of any nature, you call the police department and you instruct them that your loved one is suffering from a mental health condition. They've decompensated, they've disappeared, and they are by law required to immediately put the word out, put the information out to all the units out on the street and see if they can find them. And there's other requirements as well. So go to that website. It's really quite informative. The gal that runs that website has been traveling around the country actually trying to educate police departments in various states as well. So I just want to share with you that that's something that is an asset, the website that is, and how hard it is to deal with that. So there's been great successes as well, where people have been found, the flyers were helpful, they were able to get them into treatment, and they were able to get back to their life. But some of them still haunt me.
Yeah. If I can add, when you do file the missing persons report in Los Angeles County, there are only 4 detectives that work on missing people. And there's so many missing people.
Yeah.
You can help out a lot if you know where your loved one roams. Like if they go to Santa Monica, go down there with a photo of them, talk to the police. Talk to the homeless people. The homeless people know everybody on the street. They know more than anybody knows. And many times they'll tell you where a person is. So it's most amazing how much they know and how they know everybody out there. And when you do file that report, be sure, like Jim says, let them know they have a mental illness, because they will go to the top of the missing persons list right under missing children as a disabled adult. So that is helpful. The one more thing, if you can get DNA of your loved one, a hairbrush that maybe has their hair on it, that maybe has a hair follicle or several hair follicles, that helps. Because if they've been gone for a long period of time, God forbid that nothing terrible happened to them, but the DNA will help, because they can check out the DNA, the history on the people, and make sure that they're not any place that you would not want them to be, like a morgue. That would be horrid. No. So, okay. Treatment and placement. Jim, you want to start on that?
Sure. LPS conservatorship obtained through the hospital, generally speaking, is when the court grants the conservatorship. The conservatee will remain in the hospital until a psychiatric bed is available at an institute for mental disease, what they refer to as an IMD. Oftentimes, you hear people say it's not the most pleasant acronym to be using for these kind of facilities. I wish they would change that. These are locked down treatment facilities, and a person can only be transferred to a locked down facility from another locked down facility. You do not want to take the patient home while waiting for the IMD bed to become available, as he or she could no longer be eligible for the IMD bed. The hospital and jails are locked down facilities, as is the IMD. And Alexander, you're going to join me in this, as I understand too. So I'll read a little bit more, and let me just take a quick peek here. Yeah, let me just go through the next thing, and then Alexander, I'm going to have you jump in. The hospital should request intensive care division, which is ICD, of the Department of Mental Health, to evaluate your loved one for appropriate treatment for an appropriate treatment facility. The evaluation may take about 10 days to 2 weeks. The ICD is usually suggests about 3 facilities that may be appropriate for the mental health treatment of your loved ones. It's a very good idea for you to tour every facility by ICD. You know your loved one best and will have the greatest input for the facility that you feel will give the best probability of recovery. So you, again, have that right as a conservator. You have that authority to go, if they're saying, well, here's 3 areas that you could go to that your loved one could be held in. You can go there, look for cleanliness, ask their philosophy on treatment, what kind of food do they serve. You'd like to see their menus on their food, anything. Where would the beds be relocated? Is there a separate smoking area? Does your loved one not smoke? And you don't want them exposed to cigarette smoke. So do they have a secured area where the smoke won't affect the rest of the people that are there? And pick out the one that you feel will be the best place for your loved one to recuperate in or to be held in. So Alex, do you want to jump in here? Alexandra, I'm sorry, I keep calling you Alex.
All right. It is the decision as a conservator to make decisions about medication, treatment, placement. So in this case, placement, you do have some authority and you will oversee the placement. Your request for facilities to be honored as best as possible. There are exceptions. If you request a private facility that costs some excessive amount of money, will likely be denied unless you plan to pay for this yourself. But to usually refunded by taxes. So the decision to go somewhere really expensive, maybe Malibu. Some people might like Malibu, then usually that would be denied unless there's some kind of a good cause. If a facility will not be available in a timely manner, and a facility that's not as much as you're choosing is available earlier, then the patient will be transferred to the facility with the available bed. There's a purpose for this, and that's we don't want the conservatee to be forgotten and just left to wallow somewhere. And so if they're in the hospital and a bed becomes available, that's considered a less restrictive setting and a less restrictive placement. And once it's approved, that's by the doctor. Once the doctor clears the conservatee to be clears the transfer, it's the transfer to a less restrictive setting, a different facility. Then the ball's supposed to be rolling, and even if the one of your choosing is not available first, then they've kind of got to transfer them, and they've got to take some kind of action. You can request a lateral transfer. This is another one. A lateral transfer is not going from a hospital to an IMD. Hospital to an IMD is not lateral, but an IMD to an IMD would be lateral because the same level of restriction, the same level of confinement, and it's a lockdown facility, so that's considered lateral. And in this case, if the conservatee has been treated by an IMD and they've kind of run through the course of treatment, and then they're still displaying a lot of symptoms, and they haven't improved and met the goals of the treatment team. The treatment team will set some individual goals as part of the plan, and so these goals, you should always try to concentrate on meeting these goals. And in the case of a lateral change, maybe the goals weren't met, and they don't want to just keep wallowing there. And instead of leaving them at one facility, they may look for a facility that could maybe meet their needs and be a little more specific. And so then that would be the lateral transfer. So they, instead of going from an IMD and down to a boarding care and graduating from the IMD, they would move to a second to IMD and begin. Well, the IMD, if you haven't been to the IMD, the way a lot of those work is you have privileges, and the patient or the client will gain and accumulate their privileges, and when they first start, usually you have a bedroom and then the ward and some kind of a ward privilege or a hallway, and then you start moving around the facility, and you may meet people they may have 3 or 4 different sections of the IMD, and then you can associate with other people from the other sections and go to different classes. There, a lot of the treatments are you sit for an hour or an hour and a half and take something educational to learn to cope with the treatment, and so that's what you can expect from the IMD and from the lateral change, that that they accumulate privileges, and just like the privilege to go out and have lunch and even leave the facility, that's maybe the third or fourth privilege that's the possibility of being earned. And so the guys, usually the people really enjoy the privileges, and it gives them a reason to try to become functioning in society again. Okay, and if you request a lateral transfer, then fax a copy of your LPS. When you request a transfer, fax a copy of your LPS conservatorship paper to ICD, Intensive Care Division, so they will be able to speak with you. IMD wait times. Los Angeles is infamous now that IMDs take a very long time, and so you may be in the hospital and even start to improve, and then you wonder, do you need the IMD? But the IMD is important, and their time in the hospital can be utilized to determine the best medication for a loved one. These are medication adjustments, and to help give clarity of thinking with the least side effects. As the patient improves, another evaluation can be requested for a less restrictive treatment facility. These treatment facilities could be enhanced residential housing, which is about a step below an IMD, which is a secure facility, still secure but not a lockdown facility. Or a conservative could be evaluated for step-down treatment, sober living, or board and care. A step-down, what this is, they provide treatment programs, medication, meals, and a bed. Board and care will provide the medications, the meals and bed, and the step-down provides the treatment program, so it goes a little further. Does anybody, Mom, Jim, does anyone want to add anything?
I think you covered it very well. Thank you.
Okay, our next section here. Do we want to take a break, because we're going to have questions at the end, and we're probably a little bit past the middle. If anyone wants a 5 or 10 minutes.
Yeah, way past the middle. We're coming along towards the end. So about a 5-minute break. How does that sound to everyone?
Here's Jim.
Jim, do you need a break?
I'm having a visual problem, and I'm hoping that the aspirin will solve it. So.
Oh, you're not migraine.
Yeah.
You are, Jim.
Okay.
If you have to check out with a migraine, go right ahead.
I don't. I've never had, Gail. I don't have a headache. It's
Okay.
always a visual, so I apologize. If it gets
Okay.
too bad, I won't be able to read anymore. We'll see how it goes. That's why I took the aspirin.
Well, that'll be
Keep on trucking, you know.
okay.
All right,
Do you
we're
want
gonna
to start
take
up
a
again
break
at
here.
2:40? Is that okay? 2:40s and 5 gives us a 5-minute break.
Okay, sounds
Okay.
good.
Thank you.
Okay, great. Thanks.
Okay. Alexander, very
here.
nice. Very nice.
Okay.
It's kind of nice to see you.
Yeah, under Corona conditions.
Oh, yeah.
Just so the rest of you know, Gail's in Florida right now, and Alexander is in Los Angeles. I'm down here in Orange County. It's just amazing what Zoom lets you to put together.
Mhm. It has made such a difference for all of us, really. And I haven't seen Alexander since I left California in January, beginning of January, I think it was.
We're still in January.
Oh, yeah, we are.
Oh, well.
It's been a few weeks.
Alexander, we should make you play your violin to entertain us during our break.
Oh, okay.
Except upstairs, I'm sure.
Is the sound pretty good for everyone?
Yep, the sound is good. And Alexander, I want to compliment you on your flow today. You have a beautiful flow. Congratulations.
I feel like it's hard to talk today, but I'm talking more than I'm reading. Mom asked me not to read the material, so I'm trying to do that and talk about it all.
Yeah, that's good. Reading can be,
Boring. Yeah.
boring.
Y'all can read, so why, talk and add the extras that you need. But you're doing a good job. Thank you, Alexander. Jim, are you
Still like
still-
50%.
Yeah. Jim, are you still with us?
Where'd you go, Gail? Yeah, I'm fine. We're hanging in there. We're fine.
It's like the other night when we turned the lights off and I went to bed and I felt something's mushy underneath my feet by the bed. And I figured wasn't sure what it was. So I went to bend down to get it, but it was dark, bonked my head on the nightstand. And boy, it just knocked me out. So my husband waits now for me to get in bed before he'll turn the light off.
Funny.
If y'all have any questions, we can answer if you want to ask.
Yeah, there are quite a few questions.
I see the questions and they come up while you're talking.
But I can't read that and follow this. My mind is one
Some
track.
questions in the chat. Maybe you can let me know if they've been answered already. So
Well,
We'll have to answer them twice if we answer now.
Yeah, we can talk afterwards.
Well, will yesterday's class be available to view later?
They don't record them because people get on. We have to figure that out because a lot of people do want to see that class. In fact, Jim, did you record a little bit of it? Dr. Sharon's talk?
I did.
Oh, good.
Yeah, it's a public meeting, so you're free to record it.
That was okay. It's when we have families in it, we don't.
Exactly. So if you were to record this session, which would be really quite invaluable, you would have to keep all the questions to the end and then shut the recording off at that point.
Oh, okay.
yeah, because people give personal information.
They do.
So,
I know. Go
There's
ahead.
another question asking about the limit and extent of conservatorship. Is there
What
a
do you mean?
limit? It says, what is the limit and extent of the conservatorship? Maybe how long does it last?
It lasts a year. Is that you, Irene, that's doing that? Unmute yourself. Can I unmute you? No. Yeah.
It's 1 year. And
It's what?
Yes, and my son's is coming up, and I must say that I was so pleased since I'm on the border. I'm in Ventura County, so I've encountered some issues because I've been conservator of both my sons in both counties over the past 20 years. And
You want the first people I met. Yeah.
Very pleased that I didn't have to go into the new courthouse this year. Toby's conservatorship's 90 days is going to be in a few weeks, so I have to restart. But I was able to do everything by phone, by fax, by mail, and I didn't know the price went up, so I had to do 2 checks and do the timing, and they did the phone interview with Toby because he's always agreeable to continue conservatorship. But
How's he doing, Irene?
I haven't been able to see Toby moved to Olive Vista from 5 years at Metropolitan almost 2 years ago. And I'll say, without being able to visit him for almost a year now, I've seen some noted improvements. He's been writing voraciously, and he's been writing to me. He's working on he's doing step work in there. So he's writing these full letter size, up to 8 pages of writing, and he gets every word he can fit in there. He has such an amazing vocabulary. I can't understand everything, but I can see a lot of him in his writing, and he's clearer than he has been in the past, and he is writing and he is generating phone calls more than previously to COVID. So
That's a big change. I met Irene years and years ago. One of the first people I met you over at La Casa.
yes, and thank you for the tour. Toby finally ended up in La Casa PHF for 26 days after he was in View Heights IMD and started harming himself. I mean, standing on a chair and jumping up into the fire sprinkler. He had to go get staples in his head twice. They were talking about putting a helmet on him. I said, oh yeah, good choice. Like he couldn't take it off. And they put him in the hospital. Then they put him in La Casa PHF with one-on-one. And he got to the point where he went to Ala Vista, which I had previously experienced with his brother, had been there for a year from the jail forensically. So I have a lot of fun juggling my 2 boys, but I'm paying a lot of attention to being able to choose the residents and work more with the medication, because I am so pleased with River Community Residential. Christopher finally went there after 8 years at the Millennium House. And yeah, that's how I met you, from Peter, the Millennium House. And that's Chris's, the day he went into River Community is his day of sobriety. That's over 7 years ago. And he's stayed sober ever since, and is in now.
I don't mean to cut you off, but we probably should go on. I apologize.
Yeah, don't ever call on me. I'll never raise my hand, but I'll talk to Doomsday. Thank you.
Because we've had about a 9-minute break from our presentation.
Oh, I'm sorry, Tiffany. You should have cut it off.
No, it's okay. So I'm going to share my screen again, and we can jump right back in.
Okay.
On the criminal justice system.
Okay, that's you, Alexander.
Okay, now I guess my brain will be functioning here. But there's a doctor, and this is about what something we were discussing earlier, the renewal of the conservatorship. Dr. Harvey Friedman, I guess was his name?
Yeah.
Or it could be Friedman Harvey.
No, Harvey Friedman, I think it is.
10 years, and he's a psychologist, but he'll handle some of these hearings and some of that stuff at the mental health court. Because a lot of times, instead of having a doctor appear, or they'll waive the appearance of the treating doctor, and Harvey Friedman will sometimes conduct an evaluation, and he gets involved there.
Mm-hmm. And he knows how to testify. He knows what they're looking for. Okay, you want to get started on the criminal justice system?
That's one of the court's expert witnesses.
Yes, he is.
If you are the conservator and the LPS conservatorship was initiated and acquired through the criminal justice system, then your rights for choosing placement are more limited. Criminal court has priority over mental health court and must approve the facility for placement. The public defender should request the DMH court linkage program to be involved in the case. The court linkage program is most helpful in finding a proper place for treatment. The court linkage will work with ICD to find available beds in treatment facilities. The criminal court judge must approve the placement. Often placement will be in a state mental hospital, which is a locked facility, such as Patton, Metropolitan, or other state hospitals, maybe Atascadero. Sometimes a person may qualify for an IND rather than the state mental hospital. And so they could, from jail, the locked facility, they will end up probably in a locked facility, but it may be an IND, which is one step away from a board and care or something else that may not be locked. So an IND gets them closer to the final stage of their recovery. It is not uncommon that after the person improves with treatment, the criminal case might be wobbled down from a felony to a misdemeanor, or may even be dismissed. This to be discussed with the conservative's attorney. So that's right. In that case, a lot of times their records can be cleaned up, or their records won't reflect the original charges, and they're wobbled down. The conservatee may also be eligible for a jail diversion program. Often after 2 years under these programs, their case may be completely dismissed, even if it's felonious, so even in the case of a felony.
The jail diversion programs, they have quite a few of them. And the court linkage will help to determine which one they go into. But the results we're getting are really quite commendable. So if you have to get an LPS conservatorship through the jail, do that, because it will help them with their jail diversion program. They have to agree to the jail diversion, but they know how to make it happen. So that's helpful. Okay,
Let me cut in right here a little bit. I just want to share with everybody that I have connections inside of the Metropolitan State Mental Hospital. And so if anyone finds themselves in a situation where your loved one has been arrested because of a crime and they're being put into patent and that type of things, I do have resources for you. There's also one of the mothers that's is an executive. She's brilliant, and she has been up in Ventura where her son was. He's missing up there for a long time, and has become a very knowledgeable individual, and has agreed to talk with parents that call her. So at the end of this, if any of you want to just keep my email, or if you want me to send that to you now, I'd be glad to email it to you. I'm sorry. Go ahead, Alexandra. I didn't mean to cut you off.
Oh, I think that was about the end of the LPS through criminal justice.
Bill, I would like to say something, because I know a little bit. Well, I know a lot of it, but I just want to share something about the diversion program.
Yes.
And so it's DPH, the Department of Public Health, that has another division that we call ODR, which is the Office of Diversion and Reentry. And like you said, it's a voluntary program. But they have housing, like if someone identifies, sometimes people identify with a co-occurring disorder and also homelessness. So depending on what's going on, there are several programs. So the one I want to mention is like the setup is a house. They have an LV in there, a program manager, a case manager, and resident aides. And there's 2 people to a room, and the LVN gives them their medication, but it's housing for them, and it's a little bit of independence for them. So some of these programs are something that we've all been waiting for, and I'll stop sharing right there.
Thank you, Tiffany. I appreciate that. The jail diversion programs, it was a retired judge, that put it together, and they have I think 40 different programs, because they're trying to cover. So, well, if you don't fit in this one, well, maybe that one, that kind of thing. And I have heard nothing but good things about it. It's amazing the resources that they have access to, and the quality of the treatment. People are just really getting better, and then when they get out of the program, they do follow them and try to keep it so that they're not going back to jail for any reason. But they're getting really on the road to recovery. So I'm very impressed. I'm impressed with everything that LA is doing. It's still tough. It's still hard. But so, one thing at a time they're covering and they're taking care of. And so we are blessed. All right, let me go into treatment programs with the Department of Mental Health. 3 basic treatments, your
Right,
full
well-
service partnership. Go ahead.
Oh, about the criminal justice system and the judge. If the judge, when you show them that you're making an effort and that you've entered treatment and well, I mean, if you're in jail, yeah, I don't know that you're going to say it's by your own volition or your own choice. But if the conservatee or is cooperating with treatment, once the judge sees this and you present that to the judge, they're going to be impressed and be really cooperative, and you can plead a much lesser crime, or your things will be wobbled down somehow.
Yeah, it's some of those programs after 2 years, the case is dismissed, depending on what it is. And that's for felony and misdemeanors. Now, if they've killed somebody, that's a different story. And, it's a whole new ballgame. Okay, treatment programs. The full service partnership, anybody can call and ask for that. And the number's in the resource section of the papers. They provide whatever it is that you need, a caseworker, psychiatrist, therapist. They work to get you housing. Basically, they follow you. Now, full service partnership, a team will have about 15 people, sometimes more. So you get a lot of services, but not as much as you probably should. And I think Telecare handles a lot of the full service partnerships. Okay. Personally, I don't get a lot of feedback that's positive with full service partnership. The AOT, assisted outpatient treatment, you're going up the scale a bit. You have the team handles 10 people. They're more trained how to speak with people, how to engage them, how to get them to be involved in the program. It is a voluntary program. And if they just say, I'm not going to do it, they will send a psychiatrist to do an evaluation. And if they have to put the person in the hospital, they will. But they do try to stay with the person and keep working with them to get them on the road to recovery. If they have to put the person in the hospital and the person really needs the LPS conservatorship, which is the higher level of care, they will encourage the doctor to initiate the LPS conservatorship. So that's very helpful. AOT is a good program. Unfortunately, it really doesn't have teeth, but they're trying to get it. They cannot make the person take medicine, but when they go to court, the judge will encourage that person to take medicine. If you want to be in this treatment, this is what we're going to do, and we expect you to take your medicine. So they can kind of, through coercion, get people to take the medication, and that's quite helpful. The LPS and AOT, I really like both of those programs. DMH made it so that people can flow from one to the other as needed. You cannot have AOT and be under an LPS at the same time. But if you have AOT and you need the LPS, they will push for it. And once it's granted, then AOT has to drop off, which is kind of a shame because they really do a good job. Outpatient treatment, Medi-Cal, Medicare pays for it, the county pays for it. You do not pay for it, put your money away. If you have private insurance, they will get them to pay for it too. Now, I don't know if you've heard of John Henry Borden Care. It's a pretty successful facility, kind of pricey. If you have private insurance, Kaiser Permanente pays for it. But you can call Catherine Trapinski, and if your insurance company says we're not, class action lawsuit and get them to pay for it. And she wins her class action lawsuits. And so it's well worth it. Okay, the review, Alexander, would you like to cover that? Alexander?
Okay. I leave my microphone on mute. Okay, in review. The conservators' rights well, I guess we'll go through some of the rights. Conservators' rights are to approve and disapprove treatment, placement, and medication. Conservatorship can be transferred from a private individual to the public guardian and vice versa. Can be transferred from private conservator to the public guardian in any direction. Refer to yourself as conservator, not mom or dad, brother, sister, relative. It's conservator. Assume the title. Know all medication and keep a journal of the conservative's symptoms. You want to document and stay informed. Acquire SSI, SSDI, which is SSDI is also part of the Social Security Department. Medi-Cal, Medicare insurance to open doors for services. You don't want to forget that you, if you were employed, if they had any income, if he or she had income prior to being hospitalized, then you're going to want to file an application for unemployment benefits, and you're going to file for disability through the state, which will pay, I guess in most cases it can pay up to the 12 months of the conservatorship, the first one. And so you want to, if you have, this is in the case that you're a conservator of the estate, then you're going to want to apply for these benefits and take care of the benefits and spend them as much as possible. Visit and observe the treatment facilities prior to placement. If you see a lot of people that are on drugs, or they look like they're dealing drugs, then you may want to avoid a situation like that, because sometimes it does happen. A lot of the people that are in these facilities have similar interests and similar behaviors, and so sometimes they do these things when they socialize. Apply for FSP AOT, that's full service partnership assisted outpatient, if the person is not under the LPS, and utilize an outpatient treatment. So review, we have your conservatorship has to be renewed every 12 months. They take away the driving privileges and voting privileges, and you can have these restored. It's every 6 months you're allowed to request a rehearing on any of the rights. So, for instance, the right to enter contracts. If your conservative is living at home now, they've been hospitalized and their conditions improved, and then you've brought them back into the home and the residential environment. They may want to go out and find a job. And then when they do that, they should have their right to enter contracts cleared. And so somebody will have to call their attorney, and it's hard to get in touch with the attorneys. They're busy, and they don't really spend a lot of time with any of their clients. But try to contact them and let them know that you're at the stage of recovery, that they're going to be seeking employment, which is really, and this is the purpose of the recovery, is to reach this re-enter society. And right, so you contact the public defender, and they clear it with the court, and then they can enter contracts or any of the other prohibitions and rights that are prohibited. And then rights of conservatee. Anything that the law will tell you what rights are taken away, and so it should tell you exactly. If it's not mentioned, you can assume that it's not been taken away. So they mention like voting, driving, loss in contracts, and the right to refuse medication. So I think those are primary. But anything else, the conservatee usually still maintains their rights as a private citizen. The essence is the medication, because That's the primary course of treatment. The court will temporarily suspend the person's driver's license, the right to enter contracts. No, I'm repeating. The court, this is important. The court will take away the right to possess and own guns, not just by conservatorship, but as an admission to the hospital on the 5150. I guess you probably know that your right to, where am I? Your right to possess and own guns is taken away, and it's probably 5 years, unless you request a hearing. You can take this case to court, but it's usually 5 years. The goal of a conservatorship is to help a person live as normal a life as possible. Some people choose to remain under the LPS conservatorship as a safety net, even when they are no longer gravely disabled. This keeps them from decompensating and losing everything they gained in their recovery. I'll turn this over to Jim.
Yeah. Okay, let me just say something about the voting. They no longer can take voting away. That is against the law to do that. And unfortunately, a lot of the homeless people downtown, when it comes time to vote, California has approved harvesting vote, which is actually against the federal law. And so they'll go down and they'll get these people to vote and then turn in their votes. So, it's just kind of one of the things that they did. All right, Jim, go ahead.
Yeah, I think we're both in this together. Loss of rights. The essence of LPS conservatorship removes the conservatee's right to refuse medication. The court will temporarily suspend the person's driver's license and also temporarily suspend their right to enter contracts. Further, the court will take away the right to possess and own guns. Alexander covered this.
Covered that. Yeah, you're on right
I'm in the wrong
trial.
Or maybe the right of the conservatee?
No, the jury trial. Right of jury trial.
Okay, I'm sorry, I'm in the wrong paragraph.
Every 12 months, you're allowed a new right to jury trial every time it's renewed, and but they have a really long waiting period. I'll let Jim.
That's okay. So yes, the conservatee does have the right to a court hearing by the judge or a trial by jury. At the LPS conservatorship hearing, the judge will ask the patient if they would like for the judge to hear their case at the court hearing, or would they want a jury of 12 people to hear their case. Presently, because of the backlog of cases, the courts are taking up to 3 months before they are able to have a jury trial. If they select the jury trial, they have to have all 12 people agree that they are considered gravely disabled. Are they having jury trials right now in Los Angeles?
No.
I saw in the chat. They are still having.
They are not. No.
They're not. Yeah, I wouldn't imagine so. But in the normal case.
This is normally.
Yeah, normally. So the patient should remain in the hospital or the jail until the hearing. It is incumbent upon the conservatee to prove that he or she is no longer gravely disabled. That means that they can provide for their own food, clothing, and shelter without the help of another person. In a jury trial, the potential conservatee's attorney may state that the potential conservatee presents well. Therefore, it might be difficult to convince 12 jurors that the potential conservatee is gravely disabled and may not have a serious mental illness. If the person has a serious mental illness and is gravely disabled because of their mental illness, then they meet the criteria for the LPS conservatorship. The treating doctor will be expected to testify as to how they have a mental illness which is resulting in their gravely disabled status. Intelligence has nothing to do with the person having a serious mental illness and being gravely disabled. Very bright people have serious mental illness and are gravely disabled. It is the processing of information, the ability to recognize reality, their delusions, the ability to understand consequences of cause and effects, and many more symptoms which result in their mental illness diagnosed and being gravely disabled. And there's a lot of families that I talk to, and they say, our son or our daughter is so smart. They are so good at convincing others around them that they don't have a mental illness. And I go back to Steve Pittman and his brother before his brother, much older brother, had passed away. Said, my brother was so smart that when the cat team would show up, this is, of course, not the jury trial thing, but they would convince the cat team that his brother would convince the cat team it was Steve Pittman that needed to go to the hospital, not him. So just because somebody is maybe suffering from a psychosis doesn't mean that they've lost their intelligence at all. Want to be respectful of that.
If I can add on this.
Please do.
Yeah, mental health affects the frontal lobe and the processing of information, reality, that sort of thing. The brain works. If they were a good mathematician, scientist, played the musical instruments, could sing, could do art, whatever, those things are still there. So once they get the frontal lobe in line and working properly, the rest, you'll start seeing the brain come out. But keep in mind, the brain's been kind of sitting around, not doing a whole lot for a while. So once you start cognitive therapy, exercising it, boy, it comes out quite a bit. Okay?
So you want to jump in here? I think you're both taking. Yeah.
Oh, okay. Yeah, I can. Basically, I got to figure out where I am. Let's see. The treating doctor, we pretty much, most of this is redundant, is
Right.
expected to testify in court. If the person presents well, have 3 open-ended questions to ask them. Things that will set them off and get them off into a different direction. For instance, and not a yes and no question. Something like, so-and-so, I understand the FBI has been following you and giving you problems. What can we do to help you? Or I understand that your mother wants to lock you up for a long time. How can we help you with this problem? That will get them talking and their reality won't make sense. So it will make a bit of a difference. If they present and we talked about this already, a viable plan at court for their food, clothing, and shelter. That's all the court's looking for. The doctor said they have a mental illness. But if they present a viable plan for food, clothing, and shelter, you have to be willing to stand up and tell the judge, yes, but they're not safe. And we talked about how to do that earlier. In the jury trial, the public defender does not defend you. They defend the conservatee. They do whatever that conservatee wants them to do. County counsel represents the public guardian or the conservator. And you can request to have an attorney appointed, which they have a panel of good attorneys. They live in mental health court. So they know what's going on, but you can request to have an attorney assigned to you. And these are usually free. Now, if the person has an estate with money, then they will have to pay for that attorney. But the attorney, they're very good. They know what they're doing. They know how to present the cases, and they will do a good job. Not only that, they are there for a year for you, each conservatorship. They can help you with the estate. They can help you with problems that arise, anything. But like Alexander said, good luck getting in touch with them all the time. There are some good attorneys that are really, really helpful. Okay. I think we pretty much covered that. The jury trials take usually about 3 days. And at the end of that, let me tell you, mentally, you are exhausted, but so is the conservatee. Okay, additional rights for the conservatee. Oh, we're working you, Alexander. Would you like to take that?
Yeah, I don't know. One quick point, those jury trials, it's Finkelberg. Finkelberg a lot of times will be the attorney for the private conservator. You may want to have Finkelberg appointed. Mom would probably recommend, gives her a glowing recommendation.
I do.
When you file for conservatorship, you may be worried and think that the court case is going to go either way, one way or the other, because you don't know. I mean, in this country, you're innocent until proven guilty. That's the law. But in the case of conservatorship, it's about 98%. There's a statistic. And these cases just about tend to go not in favor of the conservatee. They're going to go in your favor, and then you'll find the doctors are going to cooperate with you. All the mental health workers and all the aides and assistants are there to kind of follow your directions, and you'll find that they're all going to be there and really trying to work for you. And a lot of them are kind of hard workers, but that statistic is about 98%, and just about everyone loses if it's a hearing or a trial. They're just about 100% there.
Yeah, it's very difficult, very stressful. But if the doctor says the person needs to be conserved and the public guardian says the person needs to be conserved, chances are they will be conserved. But keep in mind, we have judges that come on board and they're not trained. And I mentioned that yesterday to Dr. Sharon. They really should be trained. So they're looking at this like a criminal court. It's not criminal court, it's mental health court, although has to be proven beyond a reasonable doubt. So that's why I say have the questions ready and be prepared to stand up and say, no, they can do these things, but not safely. And it only applies to food, clothing, or shelter. So, okay, insurance.
The conservatee has the right to a cell phone. Now, keep in mind, treatment facilities will take away a lot of electronics and cell phones. The locked facilities will, but some facilities will allow them to have a gaming device or a cell phone, as long as they're not using it in a way that they shouldn't be using it, or if they're using it to commit a crime. A conservatee can maintain a job, can return to school as part of their recovery. They can have the right to drive a car or restored by the court, entering contracts, must have access to the least restrictive housing for their recovery. And if they're at flight risk, they will lose this privilege, and a lockdown IMD is necessary until they no longer seem like a flight risk. Must demonstrate they are no longer gravely disabled when he or she has a reappointment hearing for the LPS conservatorship or any contested hearing to be released from the conservatorship. I guess the responsibility is on the conservatee here, and they've got to prove make a case that they have recovered. Many conservatees prefer to remain on the LPS conservatorship as they recover through the recovery, so they will not lose all the progress they have made. So a lot of times, if maybe they can test the conservatorship at first, but once they're in treatment, they may be kind of going along with it from there on out. I think I'm done there.
Yeah, so what? Go ahead, Gail. Gail, we can't hear you. You're muted.
No, I had to mute it so I could ask my husband to get our dog. She started to get to be a little pistol. Okay, where are we? Was paying attention to that. On insurance? Oh, okay. The department, if you have trouble with your insurance, because the person's under the LPS conservatorship, and you have basically, if they're under the LPS conservatorship, you have access to their records. If they're in the hospital and you're not getting what you want, now that's with the exception of Medi-Cal and Medicare. They don't cover them, but private insurance, they do. You can contact the Department of Managed Care, and they will step up to the plate and help you out. They can get them in treatment facilities, more private treatment facilities if you have private insurance, and then they could do quite a bit on helping with that. So keep that in mind, that Department of Managed Healthcare. It also goes for medical. They oversee insurance companies, private insurance companies. They do overrule the insurance companies about 60% of the time. We have used them for mental health, and I think so far, batting 100 in LA when we request their services. If you need an immediate decision from them, right now they're all working from home, so they're just answering their phones. But request an emergency investigation. They can stop a hospital discharge dead in its tracks. Now keep in mind that's only if you have private insurance, and they are located up in Sacramento. Let's see. Jim, general treatment processes. You want to start that?
Sure. So basically, it says you've been granted the LPS conservatorship while your loved one is in the hospital or jail. The conservatee should remain in the hospital or jail until beds available at the appropriate treatment facility. The discharge planner from the hospital or social worker or caseworker should request the intensive care division, ICD, to evaluate your loved one for the best facility that will give him or her the greatest chance for recovery. And so often the board and cares really were so often needed, and now because of the insurance or the Social Security SSI payments not being sufficient, so many of those have gone out of business. But usually the IMD is suggested because the conservative may be a flight risk. If they're not a flight risk, then an enhanced residential housing called ERH treatment facility would be acceptable. The IMD is a lockdown facility, whereas the ERH is a secure treatment facility. The wait list for the IMD can take as long as 6 months or longer, whereas the ERH is more readily available. The patient can only access the IMD from another locked facility, such as jail or hospital. When the conservative waits in the hospital or jail, medication can be fine-tuned to find the best medication for clarity of thinking with the least side effects. The medication improves the thinking process of the patient as he or she may be reevaluated for a lower level of care. And I remember Gail talking about this at so many of her meetings. She is always saying you want to really, so that it gives you the best thinking processes of the patient in this case. But with the least side effects, you don't want them, as she's so often referred to, as being doped up or just are suffering because of the medication. So you want the least side effects with the greatest level of care. So the standard treatment flow is for the person who is placed under a conservatorship is to remain in the jail or hospital. See, I don't think I covered that until the treatment facility that is approved for them has a bed available. If the patient improves substantially, then they could skip the IMD and go to a step-down treatment facility, then to a board and care. A step-down treatment facility is just like a board and care. It's just a little higher level of treatment. Usually they have nurses available, and they're just providing more overall services, especially in the end of psychiatry. It is wise to place, I should say, nursing. It is wise to place them in an outpatient treatment program when they are in the board and care, sober living, or home. An outpatient treatment program is usually something that the hospitals run, and they have a lot of classes and sessions run by trained social workers and so forth that helps them to stabilize their lives and get back into the groove of living a normal life. So it really does help to facilitate their recovery. So Alex was scheduled here to talk about the general treatment flow. Alex, you want to jump on that?
Okay, I'll take a try. It looks like 2 cases. I see some questions about step downs. But okay, well we covered the two cases. So the first case begins with the hospital. he's taken to a hospital involuntarily, and then from a hospital, you will be transferred to a less restrictive facility, which the next step is the IMD. It's no longer the acute psychiatric hospital. It's IMD, and that's where someone can earn privileges. They can go out with a loved one for lunch. Maybe they can go home on the weekend. They can maybe take a walk in the afternoon, and so they have a lot of benefits of being of placement in an IMD as opposed to staying in a hospital. And then from the hospital and IMD, the next step would be either a step down or board and care. The IMD can go to either of those. It could go to a step down, which we just covered. That is practically a board and care with some minor differences. It's a little bit higher level of care, more supervision, and the board and care and the sober living are the least restrictive. That's where you would end up, and that's where you would try and stay once you've kind of recovered. Case 2, second case is incarceration. This is criminal justice. You get arrested and placed in a jail. From there, you might be transferred to a state hospital. And from a state hospital, it also goes, the state hospital will generally release a patient to a locked facility, which is an IMD. They could also go to a step down, I suppose, but I think commonly the state hospital is going to is going to coordinate with the IMDs, and then from an IMD here, in our case 2, IMD from there to back to step down and board and care. That's the same for both. And then with a lateral change, if a person needs a lateral change, one IMD they may have been there for a long time, and another one may facilitate maybe more cater to specific needs they have. That's one possibility. So a request with ICD for a lateral change would be appropriate. It is strongly advised as a conservator, you should visit every facility that ICD recommends. You or your loved one best will be able to evaluate the facilities as to which would be the most appropriate. If you're not pleased with any of these facilities suggested, you can request more facilities and more suggestions. Keep in mind that none of them are going to be great or utopians. Also be aware that when people first enter these facilities, they are not well, and they are expected to recover and be helped to recover, but they're not expected to be recovered whenever they're at admission. Also, you will note great improvement as their medication and treatment is working for them. Ask each facility numerous questions as to the programs or treatment, direct contact with the doctor, cleanliness, patient outings, and the facility's willingness to hospitalize your loved one should they refuse medication or decompensate. Inquire about illegal drugs, marijuana, and how the facility will handle these situations. How do they handle sexual encounters? A lot of IMDs will allow patients to have private time, and sexual encounters are approved in a lot of private in the IMDs. You want to ask the IMD, will I have direct contact with the treating doctor when I need to speak with them? Will you request immediate medication attention should my loved one need it? Emergency medication. Now the IMDs, if they don't do medication, and we might be getting a little long, but the IMDs may approve emergency psychiatric medications. They may not require a trip to the hospital under all those. Everybody calls them booty shots, and they talk about whenever they're given a kind of a heavy heavy emergency administration of the medication, then it's they administer a kind of a cocktail that's a powerful sedative or tranquilizer, and they might even do that at the IMD.
Yeah, that would be, Alexander, I think that would be like if the person starts to get agitated. If
But it happens. It's going to happen there just about every week. It's not uncommon.
Oh, that's right. Because many times the patients will cheek their medications. Because they're cheeking, then they start to decompensate. So they will give them, as you say, your booty shot to calm them down and get them back on track. Most patients take medicine. They're trying to get more and more for the shots because of the fact that people do cheek the medicines.
Okay, but one shot, they have one shot that's just a single dose, and then a lot of the shots, if you want a time release, that's also administered intravenously or something. It's and they administer those with sorry, but the shot can either be temporary or the long term. If you want a long term medication, a 30-day or longer, I think that's also done by the shots.
Yeah.
Or IM intramuscular or something.
Right. That's what they do for those. So, okay, and it's actually because they're under the LPS conservatorship, but if the person really objects to the shot, they would have to get the doctor to do a Reese hearing. And if they really object, they have to send them to the hospital to get that done. Okay?
Thank you.
All right. All right. Leaving the state of California. Jim?
Right. Transporting the conservatee across state lines. The LPS conservator is specific. The conservatorship itself is specific to California and follows the California Welfare and Institution Code for involuntary mental health treatment. And I don't think we've really discussed the fact that the Welfare and Institution Code was written 50 years ago and needs to be updated. But nonetheless, it is only in effect within the state of California. So generally speaking, once the conservator leaves the state of California, the conservatorship is no longer valid. Although if the conservator should leave the state without the permission of the conservator, the state in which they are located should, send them back. Now, this is not always the case. Many states are now establishing help me out here, I can't even read it.
Reciprocity.
Thank you, which will help in the return of the conservatee. So the reciprocity, words killing me, can also help to place a person in a treatment facility in another state. You must have the Court 95's permission to place the patient in an out-of-state treatment facility. And Gail,
That's Department 103. That's needs to be corrected.
Oh, okay.
Yeah.
For Los Angeles.
Yes.
Got it. Write that in. So Gail, you're going to jump in here with me. So you want to?
Yeah. Okay. If you're doing a treatment facility in another state, you have to have the court's permission to be able to send the person there. The East Coast is the states are doing a lot of reciprocity for involuntary mental health treatment. California at this time does not do that. So I think in time they will, but other states will pretty much honor when they find a person who's under the conservatorship, and they will tend to put them back. The Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act, that's a whole mouthful. They've made the transfer less complicated, so many states are establishing reciprocity. One of the problems is if the police pick them up, the police they can take them to the state line. They can't cross the state line. So what are your options? They do have ambulances that are certified in both states, so they can put them in an ambulance and send them across the state line. Otherwise, the police stand on the borderline and shove them over to the police at the other state. Wow. They don't really do that, but you feel like, just do it. So It does get a little bit more complicated. The public guardian's office is very good about helping when you have somebody who's gone to another state. But if they've gone with the permission of the court, that's a different situation. And sometimes that can get to be tricky. So these resource numbers, they're very helpful. Keep them. I mean, you never know when you need those. And if you look through them, there's a lot of numbers in there that you go, oh, I wish I had that one. Sometimes you're going to call me and I'm going to say, I'll be driving, so I can't look up something. I'll say, call so-and-so and take it that way. And I do try to keep them updated. They are kind of a little bit out because we have new board of supervisors and that sort of thing. So, okay, I think it's question and answer time. And Jim and Alexander, thank y'all. Alexander, sorry we're wearing you out. We did work you at the end.
We did. You did a good
No,
job.
my brain got refreshed over that break, and now I'm fine.
Okay, any questions?
So I'm going to go over to the chat for now, because there's lots of questions over here. And so someone asked if they can share the responsibility of conservatorship, like joint conservators.
Yeah.
Right.
In Los Angeles, Gail, they only allow one,
Only one.
and in Orange County they allow two.
Yeah, some other
It
counties allow two, some just allow one.
Yeah, it doesn't. It doesn't always have to be like a mother-father kind of a thing. I've seen where a cousin was actually working with the mom. They both took a hand in that. Both were conservators.
And then, do you have to have a certain type of relationship with the person to be assigned as a conservator? Like, who's qualified?
Well, I'll put my 2 cents on that, Gail. I know you've got things to say about that as well. And usually, if there's no real friction between the two parties, it's not an issue at all. But I won't bring up what drove our son to be put onto a conservatorship the first time. But there was this tremendous, horrific contention between he and I. And they didn't even tell me about conservatorship. They just put him right on a public conservatorship, put him into an IMD for a year. And later, when I found out that I could be a conservator years later, I actually approached the public guardian's office here in Orange County. And the first question they asked me, I said, well, how are you and your son getting along? I said, we're getting along really well. And so after I spoke to him as well, there was no issue in that. Gail?
Okay, in LA, they prefer a family member be a conservator, but you don't have to be a conservator. A responsible person, somebody who's responsible, and the public guardian does the investigation to find out who is responsible, and then they take it from there. But if there is a problem, they will transfer it back to the public guardian right away. The conservatee, the person who's being conserved, has the right to say, I don't want that person, or I do. And I'll give you an example. I had this one couple, they were small people, but their son was, tall. And in court, the mother was going to be the conservator, and he told the judge, I don't want my parents for conservators. My parents beat me. He kind of looked at that and thought, I think it may be the other way around. But so the judge says, okay, we will make the public guardian the conservator, but we're going to have a rehearing on this in 30 days. Of course, they started the medication for him and all. This is the days when you could go to IMDs pretty quickly. Goes to the IMD, and he calls his mom after 2 weeks. Well, Mom, if you're real nice to me, I'll let you be my conservator. She says, I don't want to be your conservator. You're not nice to me. Before the court hearing, he called his mom, Mom, I'll be real nice to you if you'll be my conservator. They get in the IMDs, they get in places, and they find out it's almost like they languish. There's nobody there supporting them, coming for lunch, taking them out for lunch. You can't take them out if you're not the conservator, unless the conservator gives you permission. So many of them say, I want my family for the conservator. Maybe not at first, but eventually. Okay.
So this other question is interesting because we have interesting experience between people who have, a mental health condition and law enforcement, right? But someone has heard that the police have been advised legally not to physically touch mentally ill people. Has anyone had this experience, and how do we deal with it?
Go for it, Jim.
I have. Here in Orange County, there's a police officer that is in a working group of nature I won't go into, and he informed me that there is a legal advisory committee or entity in the state of California that advises law enforcement on different legal issues, and told me that that's in fact one of the things that they were advising police departments not to do, is to, when somebody's being transported into the hospital, not to put hands on them. I've had an exception to that. I here in Westminster and Orange County, typically it's always the ambulance that will transport. And the last time our son was transported, the police officer, one of the sergeants themselves, took our son, which was a first. Took him into the hospital and got him checked in. But in times past, the CAT team arrived. They assessed our son. They spoke with him at length and so forth, and said, "Yeah, you really do need to go into the hospital." And there stood the ambulance driver, the gurney, the two officers, and myself, and the owner of the board and care, and they were trying to tell our son to get on the gurney so they could get him into the ambulance, and he refused. And I looked at the officers and said, "Officers, can you please assist the ambulance driver here? We need to get our son into the hospital." The health department was really wanting to see him go in. And they said, "I'm sorry, we're not going to touch him." And it's a story I told yesterday, I believe. But the police just would not lay. And so I've actually had conversations with them. I said, "So if I go into a store and I steal something without paying for it, and you're called out to the scene and happen to be close by and come immediately, and you're telling me that you're going to have to arrest me, and I take off and I run down the sidewalk, you're not going to chase me? You're not going to stop me and grab me physically?" He said, "We may not." I was dumbfounded by that. I mean, I don't believe it, but that's what they were telling me anyway. So it is a serious problem. I know this is something that we need to look at. From what I'm hearing, Los Angeles doesn't seem to be encountering that like we are out here in Orange County. But it has absolutely been a problem.
The sheriff department tends not to want to put hands on people, but so far we're kind of okay with the police, but our police are trained with CIT pretty well, that many times they can convince somebody to do something. But with all the lawsuits, when I was talking to the head sheriff, whatever he was called, they're very concerned about lawsuits. Many times when they go out and they're assessing somebody, everybody's got their cameras out.
Yeah.
So they're being very careful because they're going to be sued. I mean, it doesn't matter what they do or don't do. They're looking at possible lawsuits. So they're kind of like, okay, I'm not going to do it. And that's where the problem comes into. But you don't want them tackling people and smashing their head on the ground and that kind of stuff either. But we've done a great job with CIT training, although that has stopped now, that they have pulled, I think what it was, $150 million from the LA police. It kind of makes me wonder. Okay, next question.
So, did you guys cover CIT at all yesterday?
No, not really.
Okay, just for anyone who doesn't know, CIT is crisis intervention training, where law enforcement, so it could be 911 operators, people from the VA, the FBI, mostly police department and sheriff. So this is custody and patrol. The crisis intervention training is giving them like a mental health training. And in part of the training, NAMI does a presentation offering NAMI as a resource. And then part of the presentation, or I should say the two presenters, one is someone who is a family member of somebody who has a diagnosis, and another presenter is the person who actually has the diagnosis. So they get like a person with lived experience telling their story. And I believe the intention is to tap into their compassion and empathy with these stories to help them know, these people are loved by somebody. Let's treat them properly when you interact with them. So I'm a fan of the crisis intervention training, as you can tell.
I have seen a big difference with the police. When they've had the crisis intervention, they love it. They really love the training, and they say they look at things entirely different. So it is one of the best things I've seen happen. I'm so sorry it's kind of being pulled.
Mm-hmm.
But what are you going to do?
I believe it's because of COVID. I have had the blessing and the opportunity to be a presenter.
Mm-hmm.
And so it was a wonderful experience for me. I will say that.
It is. They do a good job. They really do a good job. Okay.
So another question is, when I pass away, my daughter has agreed to be my son's conservator. How do I arrange this ahead of time?
She just has to go to the court when that happens and just ask for the succession when it happens.
Okay. And another person wants to know where to find the conservatorship procedure.
Basically, I would go back to the paper that we had yesterday, the LPS Conservatorship paper, and that walks you through. You can read the paper especially when you have insomnia. It'll help. So,
And they do. I mean, you'll be hospitalized, and then if you're hospitalized and it's extended to the 2 weeks, 5250, and then I think at that time they start filing the petition, and they start working on the petition, and then it's so if he gets admitted to the hospital, and then he gets the extension, he or she, and then what comes next is the doctor's going to file that form, and it goes to another extension, and it goes to the court, and during that 30-day extension, then you have a hearing in the court for probable cause or something like that. And so you get a hearing for the 30-day hold, and then I think it's either jury trial. They have one more hearing after that.
not after the jury trial. That's final at that point. But
no, the jury trial is after the probable cause hearing.
Yeah, after the probable cause hearing and all the 50 million writs that the patient can request in between.
So it's probably two. You probably have to go to two hearings. But the one hearing maybe, so the jury trial could be a hearing, you'll have that and maybe one hearing.
Well, they've changed it now. The law, what they were doing before was really not the way the law was set up. You would go to court at Department 103 and you would have a hearing with the judge. If you didn't like what you heard from the judge, then you would request a jury trial. You don't get both. You get either a court hearing or a jury trial. So they do what they call a court setting. You go to see the judge. He says, do you want it heard by the court or by the jury? But with COVID, they're not doing jury trials. So that's out of the question. But normally, if you say a jury trial, they set it up and they were backlogged like 3 months. So you would have to sit in the hospital or the jail for 3 months until that could take place. If you did the court trial, they would do it within a day or two. And that was the judge who would make the decision. And almost everybody was doing the court trial. Okay, but they can find everything they need on that. Let's see. On this, the LPS Conservatorship information paper. And that was sent out yesterday. Yes. Okay.
What if your loved one
Go ahead. I'm sorry.
What if your loved one refuses blood work?
If the court tells them you have to go to court to get the blood work approved, because that's kind of invasive when they start sticking a needle in your skin, and they pretty much will approve it, then they cannot refuse it. It's a done deal. And they will have people hold them down if they have to. But usually once the judge tells the person you have to do this, they don't want people holding them down, so they usually don't fight that.
Okay, so relating to the next question, I will say that the Martin Luther King Hospital has a behavioral health center. But the question is, I heard that near MLK Hospital, a mental health hospital is opening, but they couldn't find anything. And they want to know, is it a private project or a Los Angeles County Department of Mental Health project?
I can't answer that, but I kind of think it's the LA department. Listening to Dr. Sharon yesterday, he mentioned that they're trying to open up facilities over there, but they for sure. And somebody, go ahead.
I know there's a psychiatric urgent care and there's this behavioral health center. So it could be, I would recommend calling and asking questions there, because I'm pretty sure they know what's going on.
Right. And somebody asked about that paper, how to get to it. Email me and I'll send it to you. That's Gail, Gail, the number 4, dine as in dinner, DINE, and I'll send it to you. Okay?
Do you have resources for gravely disabled homeless?
I do not deal with the homeless. Because I don't do the work. I just give the family suggestions what to do. Jim, how about you? Because you're in Orange County.
Yeah, no, I'm not involved in that either, Gail. There's groups that are nonprofits. One's called Our Father's Table, and they have an excellent track record of helping people get off the streets with really not any recidivism involved at all in that. But, you know, of course, I don't know what's going on in Los Angeles, but that's the only group that I'm personally aware of for Orange County.
If a family member has somebody who's homeless that they're trying to get into treatment, I will work with the family, but I don't go out and do the homeless. I mean, that's just not possible.
So I do.
You
work
do?
With the homeless.
Oh, Tiffany.
Good for you.
And so.
Good for you.
Awesome.
Thank you. So I don't know, is LaTanya still on the call? Or is she gone?
No, I'm still.
Which is she?
Oh, there she is. Hi, LaTanya. What part of Los Angeles do you live in?
I'm in South LA, Manchester, Broadway area.
Oh, okay. So you are right there by Hoppix.
Right.
Is on Manchester and Broadway. Talk to Hoppix about Project Room Key. Project Room Key is for anyone over 65. It's because of COVID. LA County has rented out hotels. So anyone over 65 or anyone with an underlying health condition qualifies to be a guest in a hotel in LA County, and Hoppix is one of the service providers.
Thank you for that.
Thank you, Tiffany.
And I know here in Orange County, there was a lot of people living down by a riverbed, and one of our local judges just went through there and got everybody moved into motels and so forth, hotels.
Was that Judge Carter?
Yeah.
Judge Carter?
Yes, it was.
Okay. So what happens if the person who fights being conserved demands a jury trial? And there are no jury trials right now. What happens?
The court will make the decision. And almost a good portion of the people fight LPS because they don't think they're ill. I mean, it's just the nature of the illness. And that's why it's called involuntary mental health treatment. Because they don't volunteer for it. If they did, we'd have them in AOT or something else.
So this information may be on the resource page at the end, but it says, is an attorney available to conservators in LA County only or is that a state requirement?
Jim, what about Orange County?
You mean provided by the courts or the judicial system to represent the homeless?
Kathy, no, this is a different question
I'm sorry.
outside of the homeless question. So,
Okay.
Kathy, do you want to elaborate on your question? Is an attorney available to conservators in Los Angeles County only, or is that a state requirement?
Yeah, I'm in Sacramento County, and I've been doing the renewal on my own here without an attorney. And I heard that LA County offered it, but I've not been offered an attorney here in Sacramento County. So I didn't know if that is just something that LA County is being generous and offering to families, or if it's actually something that should be happening across the state.
I would think because you're dealing with the judicial system, we have to ask the judge, the families ask the judge or the conservator, who's ever going to be the conservator, ask the judge to assign them an attorney. I think I would do that. Go back and ask the judge to assign you an attorney who can help you with your Social Security filing, like when you have to file every year, the benefits and all that sort of thing.
Yeah, that's
any
easy.
questions you have? Yes, it is. But
Yeah.
any questions you have that may arise, you should have access to an attorney.
That sounds good to me, but as of now, just last week, the renewal or the reappointment was granted, so I don't need that now. No reason to go back and ask the judge. But for next year, it would be a good thing to know.
Yes.
So
Definitely.
just basically ask the judge to appoint an attorney and see what happens.
Right. And I'd probably even do it during the year in case you run into a problem.
That's
You
a good
never-
point. All right, thank you guys very much. Thank you.
Okay.
Okay, can you go over the step down process again? So someone's asking for the step down level, what it includes, and the official name of a step down facility on the license.
Well, in Orange County, step downs are not something that a family can take their conservatee to. That's generally provided when they're in a hospital treatment environment. And then there's actually somebody within the Orange County Department of Mental Health that is in charge of the step downs. And if the determination is that the individual needs to be in a step down, then there'll be somebody from the Department of Mental Health that will help facilitate that and put it together. But board and cares provide somebody that's going to provide the medications, your meals, and a bed. There's different rules and different outcomes for different board and cares, but that's the gist of board and cares. And your step downs are just a higher level of care with nursing staff available. And they're just more involved in the individual's daily life. A lot of your public conservatees are in some of the step downs, and they pretty much just turn everything over to the step downs in those cases.
And so does it happen internally, like maybe someone is doing well, and so they're allowed to transfer to
the step down. But before they go to the step down, ICD, Intensive Care Division, will do an evaluation. They do the evaluations of the person to determine which IMDs would be most appropriate. They can go back and do an evaluation as the person's in the hospital because they're there for a long time. And the medications are really working. They can go back and do another evaluation and say, we don't need the IMD. We're going to do a step down. And then they would recommend several or give several suggestions. They can even go and say, this person has improved so much. We're going to suggest maybe a board and care. Now, if the public guardian is the conservator, they can only put the person in a state certified facility, where a private person can put them anywhere, someplace else. I hope that helps. But it's ICD that has to do the evaluation and open the door for them to be able to go there.
Yeah.
If the conservative wants a lesser restrictive placement after LPS is established, would they ask the court for a writ of habeas corpus?
They could, no, they can ask ICD for the evaluation, and ICD will make the recommendation.
I might not totally agree. I don't know
Okay.
if I can say something.
Right.
Okay, let me see the question. After LPS is established, would they? Well, okay, yeah. I mean, the answer to the question is yes, but it's not, because it's not called a writ of habeas corpus. habeas corpus. Habeas corpus. That's the correct name of the hearings you request. But this is a different time. This is once you have the conservatorship and you no longer have that habeas corpus right. But just like when I covered the section over the driver's license, right to enter contracts, and all those different rights, their disabilities imposed is what the court says, and so you have a right to request your hearing for the driver's license, and the placement really works the same way. It's like every 6 months, but you've got to go to the court, and the burden of proof is on the conservatee to prove to the court why you don't need the level of treatment that you're in, and you're ready for a lesser restrictive placement. So I guess it's about every 6 months as a rule. So if you have 12 months conservatorship, I guess you can apply. But if you apply at the beginning, it's not going to do any good because you haven't had the time to recover. And your attorney will advise you of that too. But it's a special hearing, but not called habeas corpus.
Someone did.
The habeas corpus is more to be released, to request to be released. That's when they file for that.
Yes.
Okay.
Someone's requesting a copy of yesterday's training.
And just ask them to email me. That's Gail, Gail, the number 4, dine as in dinner, DINE @gmail.com, and I'll send it to them.
Okay, I just put that in the chat.
Okay. That's
So, someone says that last year a paralegal called them and said their firm had been assigned to represent her in renewing the conservatorship. And she never figured out why they did that, because she could have handled it herself, even if remotely. And she's asking, is that common?
Did they charge her?
And that she was given misinformation about driving privileges. So, Lindsay, would you like to come on regarding your question?
No, they didn't charge me, and I asked the paralegal, why are you doing this? Nobody ever represented me the other 5 times I got it renewed, and she didn't know either. So I'm sure she billed the state of California or county of LA for a lot of money, and I don't know why they told her to represent me. She wasn't representing my son, she was representing me as the conservator.
I've never had anybody call. They usually do tell you who will be, they will have an attorney representing the conservator, or county council pretty much does it. I've never heard of that.
Yeah.
But I found many attorneys are misrepresent. They don't really know everything. The driver's license, they don't always understand that or know that. That's why we teach this class.
Yeah.
I've had a lot of people call because they need a conservatorship. They don't know the difference between an LPS and a probate. They'll call an attorney and the attorney wants to charge them money. Yeah, I'll get the conservatorship. When in essence, if they go to probate court, the judge is going to say, no, that belongs in LPS court. And meanwhile, the attorneys charged them a bundle of money. And you can't just go into LPS court. It is the treating doctor that has to initiate that conservatorship. So a lot of times I get calls, and I'm not going to tell somebody not to hire an attorney. That's their choice. But I will give them enough knowledge that they will know what they're talking about.
So this year, now that we're doing everything remotely, I guess if they don't call me again, I just send in the papers and the doctor's letter and all that stuff. We just do it all by mail.
Yes.
Yep.
And
Correct.
do they have a hearing that I appear at remotely? Because this time the paralegal said that the attorney was going to show up for me. That's
Well,
what she said.
the attorney will show up, but I would request that you be on that WebEx call. If you are the conservator, I would want to be on the WebEx, because we've had cases where the conservatee will make a case for, gravely disabled, how they're going to handle it. And it could be really a fraudulent situation that they're doing, but the judge doesn't know the difference. That's why I'd be very adamant. I want to be on the WebEx and be able to speak if need be.
So I do have a right to attend.
Yes.
Yep.
Yeah.
Okay, I'll make sure I do this time. Thank you.
Okay.
It's 4:01. We have two more questions. Jim, did you want to say something first?
No, I agree with Gail. I just went through that and we did it through WebEx here in Orange County. Go ahead, just hit the next question.
Okay, is there a list of step downs?
You have to call the Department of Mental Health and ask them. They can give you the list because it's constantly changing. I don't get very involved in that. I would call ICD and ask them for the list. They'll give it to you.
How can I get a public attorney to start the conservatorship?
The public attorney does not start the conservatorship. Only the treating doctor at the hospital or the jail. Now, they do have the outpatient, but I wouldn't even bother with that at this time.
So that was the last question.
Okay, so, and also if they don't have the information from yesterday, I'd recommend they again reach out to Gail and get transcripts of yesterday's course, because that sounds like they weren't there or they wouldn't ask that question.
Mm-hmm.
Renewal of conservatorship. They may the form used to have 2 fields or two spaces for the doctors. So, and usually your conservatee is seeing one physician, one treating doctor, and so their signature is mandatory, but then you might have to acquire that second signature. I mean, maybe things are a little different now and with COVID, but it used to be that sometimes it was 2 doctors that would sign the form. I don't know if we said that today.
Actually, it was one doctor in LA had to sign the form, and the courts were accepting that till a particular person got up there and said, oh no, I want 2 people to sign it. And then the court had to change that, and now they're requiring 2. Because the court sometimes, they don't always follow the law the way it's supposed to be. They just kind of go with what everybody else has been doing.
Oh, wow.
And there are sometimes attorneys or conservatees that get in court and they go, that's not the way it's supposed to be. And they know more than what the judges and attorneys do. So it is quite interesting to see that. But usually the treating doctor will know another doctor, have the doctor talk to the person, and then they can sign off.
And that's where there's always Dr. Harvey Friedman.
Yes. And he's always at the court.
Okay, so
We're done.
we are done. Someone's asking about